Question 30. Explain conditions and warranties and rights of unpaid seller. Welcome KSLU LLB students to this intensive exam prep masterclass. I'm your professor for today, and listen to me very carefully because we're going to systematically dismantle one of the most critical questions in the Sale of Goods Act 1930. If you follow this exact blueprint today, word for word, structure for structure, I guarantee you're going to secure maximum marks for this 16-mark long-form question. Now, evaluators are looking for precision, right? Not philosophy. So speaking with strict academic authority here, to signal total mastery to your KSLU evaluator right on page 1, you literally must write an exact agenda under the heading Synopsis at the very beginning of your answer script. Let's begin.
1. Question and introduction blueprint. 2. Conditions versus warranties. 3. Implied stipulations and exceptions. 4. Defining the unpaid seller. 5. Rights against the goods. And 6. Personal rights and conclusion.
Section 1. Question and introduction blueprint.
The Sale of Goods Act 1930 distinguishes between conditions and warranties and provides remedies for breach. It also protects an unpaid seller by granting special rights against goods and the buyer. Okay, we're now entering the very first segment of your actual written answer. A precise, statute-focused introduction sets an absolutely uncompromising academic tone for the rest of your paper. Note this carefully, students. By writing these 2 exact sentences, you demonstrate a high-level understanding of the Act's dual purpose. You're not wasting the examiner's time on irrelevant stories or historical background. You are hitting the nail on the head immediately, and that's how you score.
Section 2. Conditions versus warranties. Condition, Section 12, subsection 2. A condition is a stipulation essential to the main purpose of the contract. Breach leads to the right to repudiate the contract and claim damages. We are now transitioning into Part I of the statutory framework, so pay close attention. Your accuracy in citing section numbers right here will literally make or break your score. I want you to take your pen and strictly underline Section 12.2 and the word essential on your exam script. Why? Because a condition goes to the very root of the contract. If a condition is breached, the foundational purpose of the entire transaction just collapses. And that is exactly why the law grants the aggrieved party the absolute right to terminate or repudiate the entire contract and ask for damages.
Warranty, Section 12, subsection 3. A warranty is a stipulation collateral to the main purpose of the contract. Breach leads to only damages, no repudiation. Again, grab your pen, underline Section 12.3 and the word collateral. You need to contrast this sharply with a condition. A warranty is entirely secondary. It's a subsidiary promise. If it gets broken, well, the main purpose of the contract is actually still intact, meaning the contract must legally continue. The buyer can't just reject the goods. They can only sue for the damages caused by that specific breach.
Let's read this strictly row by row. Basis, importance. Condition, essential. Warranty, collateral. Basis, breach. Condition, repudiation plus damages. Warranty, damages only. Basis, effect. Condition, contract may be terminated. Warranty, contract continues. Listen to me very carefully. You must always draw this exact table using a pencil and a ruler on your exam script. I'm serious. KSLU evaluators are actively looking for this specific tabular format in distinction questions. It beautifully breaks up the text and provides a visually perfect summary of sections 12.2 and 12.3.
Section 3. Implied stipulations and exceptions. When condition becomes warranty, Section 13. Step 1. Waiver by buyer. Buyer may waive condition. Step 2. Acceptance of goods. Buyer treats breach as warranty. Step 3. Indivisible contract. If goods accepted, condition becomes warranty. Alert yourself, students, because this is where average answers are separated from the distinction level answers. You must demonstrate knowledge of statutory exceptions and implied terms right here. Section 13 basically operates in KSLU problem questions as a mandatory legal trigger. Sometimes, a buyer might just choose to forgive the harsh breach of a condition and simply ask for compensation, treating it as a warranty. Or, if the contract is completely indivisible and the buyer has already accepted the goods, the law forcibly downgrades that condition to a warranty. Mentioning Section 13 shows you truly grasp the dynamic nature of these stipulations.
Implied conditions. Condition as to title, Section 14. Sale by description, Section 15. Sale by sample, Section 17. Fitness for purpose, Section 16. Merchantable quality. I insist strongly that you must memorize and write these precise section numbers adjacent to each condition. If you just list the points without the bare act sections, you're going to lose marks. It's that simple. By citing sections 14 through 17, you prove your rigorous academic preparation to the examiner. Case law, Passard versus Spears, distinguish between condition and warranty based on importance. Now pause what you're doing and instruct yourselves to draw a prominent box around this case name with your pencil on your answer sheet. Let's break this down deeply because it's absolutely crucial. The facts of Passard versus Spears are vital. Madame Passard was an opera singer hired to perform for a specific season. Sadly, she fell severely ill and missed the crucial opening night plus the first few days of performance, so the director replaced her. When she recovered and tried to rejoin, she was flatly refused. So what was the verdict of the court? The court held that performing on opening night was the very root of the contract. Her failure to perform was a breach of a condition which legally entitled the director to repudiate the contract entirely. This case is your definitive proof of how an essential stipulation actually operates. Underline this case name to immediately capture the evaluator's attention for a 16-mark answer.
Implied warranties. Quiet possession. Freedom from encumbrances. Disclosure of dangerous goods. Briefly, quiet possession just means the buyer has the absolute right to enjoy the goods without any interference. Freedom from encumbrances means the goods are not pledged to some third party. Remind yourselves constantly that these are strictly collateral to the main contract. A breach here only yields damages, nothing more.
Section 4. Defining the unpaid seller. Meaning of unpaid seller, Section 45. Seller is unpaid when price not paid or tendered or conditional payment dishonored. We are now announcing Part 2 of your answer blueprint, shifting the examiner's focus to the statutory remedies available to a seller who simply hasn't received their due. The critical importance here is citing Section 45. But what does conditional payment dishonored actually mean in the real world? Well, it means the buyer gave the seller a negotiable instrument, like a check or a bill of exchange, and it bounced or was dishonored by the bank. The very second that check bounces, the seller instantly legally transforms into an unpaid seller, now fully clothed with special rights under the Act.
Section 5. Rights against the goods. Rights against goods. Number 1, right of lien, Sections 47 to 49. Retain goods until payment. Number 2, right of stoppage in transit, Sections 50 to 52. Stop goods in transit when buyer becomes insolvent. Number 3, right of resale, Section 54. Can resell goods if perishable or after notice. We transition now to the specific powerful remedies the unpaid seller exercises directly over the physical goods themselves. These are known as rights in rem. Let me deliver a deliberate classroom explanation on organizing this for your paper. Do not just jumble these up. Group them exactly like this with their respective section numbers. Think of it chronologically. The right of lien applies when the seller still has physical possession. If the goods have left the seller but haven't quite reached the buyer yet and the buyer suddenly goes bankrupt, boom, you use stoppage in transit. And ultimately, if the money just isn't coming at all, the seller can use Section 54 to resell the goods to a third party.
Case law. Lickbarrow v. Mason. Established seller's right of stoppage in transit. Take your pencil and box this case name immediately on your paper. This is an absolutely mandatory citation. The background of Lickbarrow versus Mason involves goods that were shipped, and while they were literally out on the high seas, the buyer became insolvent. The seller swiftly intervened and ordered the ship's master not to deliver the goods to the bankrupt buyer. The ratio decidendi, the core legal principle established by the court, was that an unpaid seller has a definitive, equitable right to stop the goods in transit to prevent them from falling into the general pool of the insolvent buyer's assets. Its absolute relevance to Section 50 simply cannot be overstated. This case is the genesis of the statutory right. Write this down clearly to secure those final crucial marks.
Section 6. Personal rights and conclusion. Rights against buyer personally. 1. Suit for price, Section 55. 2. Suit for damages, Section 56. 3. Suit for interest, Section 61. We are now directing ourselves to the final components of your 16-mark answer script. A strong, comprehensive finish is just as important as a bold introduction, right? Let's clarify the academic distinction here. The previous rights we discussed were against the goods themselves. These are in personam rights. They are filed against the buyer directly in a court of law. If the property has formally passed to the buyer, the seller sues for the price under Section 55. If the buyer wrongfully refuses to accept the goods, the seller sues for damages under Section 56. Exact section citations here will absolutely guarantee full credit.
Conclusion. Conditions and warranties determine the nature of contractual obligations, while rights of unpaid seller protect the seller against non-payment. Together, they ensure balance between buyer and seller. Read this carefully, students. Ending your answer booklet with this perfectly balanced paragraph will solidify your top-tier score. It tells the evaluator you don't just know the sections, you understand the macro perspective of the statute. And I want to leave you with this final provocative thought. Mastering commercial law isn't just about memorizing sections. It's about deeply understanding how the law meticulously constructs a safety net, balancing the aggressive momentum of trade with the fundamental human need for fairness and protection. Study hard, write exactly to this blueprint, and you will absolutely conquer this exam.